Morning, everyone, and welcome to the meeting of the Justice Committee that everybody is waiting for today. Our discussions on Bill C-84, an act to amend the Criminal Code, bestiality and animal fighting. I'd like to welcome the students group that's here today. It's great to have you. I think all of the committee is excited to have so many people in the room on our clause by clause on a bill. Clause by clause means that we're going through amendments to a bill, and this is a bill that was proposed by the government, and different committee members have heard from witnesses and will now be proposing amendments. It's a pleasure to have Mr. Davies and Mr. Erskine Smith join the members of the committee this morning. It's also a pleasure to be joined by witnesses from the Department of Justice, Madame Carole Morency, the Director General and Senior General Counsel, welcome, and Ms. Paula Clark, Counsel Criminal Law Policy Sector, welcome. And they'll be helping us if we have questions on any of the amendments. So we get to the list of amendments, and the first clause that we're calling is Clause 1, and the amendment that we have to Clause 1 is Lib 1. Lib 1 is essentially the identical point as PV2, NDP2, and CPC1, just put in a different part of the code. But it has exactly the same effect to apply rules to a conviction in the bestiality section. That means that people can't own animals that are in different sections and that didn't apply to this offense. So each of these amendments, PV2, NDP2, and CPC1 would become moot if Lib 1 was adopted because it achieves the same thing. Mr. Erskine Smith, this is your amendment. You have the floor.
It's pretty straightforward. Others have put forward similar amendments. It's to get at what witnesses brought forward, and I think there was unanimity on this subject, so I'll leave it there. I think it speaks for itself.
Mr. Davies.
Thank you. Well, the NDP supports this motion. Obviously, we have an identical motion, but I had a question really of drafting. In 5B, the wording is, it says, compel the accused person to pay for the care of the animal they allegedly injured. And we're wondering if that's the proper terminology. By definition, the person would have been convicted. You wouldn't compel the accused person to pay. You would compel the person convicted of the offense. So as a matter of drafting, I think that that would be a concern I'd raise with my colleagues and see if we shouldn't change that.
Let's ask perhaps the department officials. Madame Morency, Ms. Clark, could you comment on that? I think that language is already in the criminal code in a different section. Could you explain why it's accused and not the person convicted? My criminal code in front of me.
The language that's used in the motion is identical to the language that's already used in section 447.1. The reason why the term accused is used is simply because it's used in other areas in the criminal code. And as far as I believe, the term convicted individual is not used in the code. But what's that? Yeah, and as well, it's if you look at the chapeau in 447.1, in subsection 1, it refers to the court may, in addition to any other sentence that it may impose, so that would lead the court to conclude that there has to be a conviction.
I understand. Mr. Erskine Smith?
I had a question, actually. Obviously, in getting this drafted, it's through legislative drafters, and I know there was some conversation about redundancy about animal versus bird, and I wonder if you could comment as to whether it makes sense to just say as an animal and delete or a bird.
we would support removing the phrase "or a bird." And in Section 160, the definition of bestiality does not include "or a bird," so that would be consistent with the terminology in the section.
So I think it makes some sense. I hadn't caught it in first instance, but I think it makes some sense to amend it by striking "or a bird" after "as an animal" or "a bird" in both sub A and sub B. Sub B, I think it occurs twice, but in each instance, striking that, I think it makes sense given Section 160.
So in section B, you're proposing to strike "or a bird" in lines 3 and 4?
3 and 4, and then again,
In
Or
line
bir-
3 of,
"or bird" in the second last line there.
and what about in paragraph 1?
In paragraph and sub
the third
A,
line?
In sub A, it's third line. Yeah, I think it makes sense.
Mr. Davies?
So I think we have two issues we're talking about. I was going to go back to the point I was making earlier, but I don't want to. Sure. Well, I just want to say I don't think it's a huge issue, but I'm looking at other sections of the criminal code, in particular section 740, which is restitution, and it uses the term offender. An offender who fails to pay out the amount. The court is considering ordering the offender to pay a fine. I'm just wondering if, and again, I think we all know what it's meant to mean, but I'm just wondering if this section shouldn't say compel the offender to pay for the cause. Maybe that's a better term than accused. I still think accused is not the proper term to be used here.
Rusty?
So I would agree. In terms of the basis, the rationale, or the model used for it is the one that exists now in section 447.1. And in there, it does use the accused. But I think the point is correct that normally today, if everything were to be completely modernized and updated, normally the language would be the offender, because this is part of the sentence that is imposed on the person who is convicted. The point that my colleague made that is missing from Lib 1 before the committee right now is the language that appears in 447.1 in the chapeau, which is in addition to any other sentence that it may impose under. That's important. I would suggest that for the committee to consider, because it is being a clear signal to the court. This is part of a sentence that should be imposed. So I think there is that other distinction that committee may want to consider.
So you're proposing that we would start this sentence by saying, identically to 447.1, the court may, in addition to any other sentence that it may impose under subsections, and then we would say 444.2 identically to there?
I think it would end in addition to any other sentence that it may impose,
Yeah.
comma, and then you have A, B, C, or A, B,
Okay, I understand.
with the changes that have been noted about the deletion of or bird. I think one of the other distinctions would be perhaps the legislative drafters would comment that normally you would put sentencing provisions together in a provision, and here I guess you've got the definition that Bill C-84 is proposing as subsection 4, and Lib 1 would propose to put the additional penalty provision after the definition. I mean, in the end, I guess it's all there, but it's probably a drafting thing.
Sorry, Mr. Erskine-Smith?
Just for clarity, because I think I'm more comfortable with respect to ordering payment that it be the offender. Is that the only subsection, or are you also suggesting that the prohibition from owning or having custody or control or reside in the same premises would be accused or offender? Because I can understand there why it might actually be accused in some instances.
Well, I caught it specifically in subsection B.
Yeah, that makes more sense to me.
I think that's the only one I would think, but I see what you mean, because, well, it depends if are you thinking that there could be an order made
Like an interim
pending
order.
conviction?
Exactly.
Yeah. Yeah, so I think it's broader in A, so it should be accused there.
Yeah.
But I think B should definitely be
That makes sense to me
offender.
as well.
So I just wonder about the inconsistency between this clause and the existing section of the code. I assume that if I'm incredibly lenient, we could then propose another amendment to amend that section of the code as well. But I'm wondering, is there really, I mean, given the fact that the court would have to impose a sentence in order to get there, is there any possibility that someone who has not been convicted would be touched by the word accused in B? Because the court must be imposing a sentence in order to get there. I agree the word offender is better, but I'm just wondering about having the same paragraphs in two sections of the code with inconsistent wording. Mr. Davies?
I'm not sure where the inconsistent references that you're referring to. Could you help me?
So this is a cut and paste
Yeah.
from sections 440, is it 447, 1, A and B, which is called Order of Prohibition or Restitution.
So you're saying, Mr. Chair, that there's some other section that still uses the term accused?
Yeah.
The current section, 447.1.
Yeah.
Yeah, exactly. A and B. So I don't want there to be a question of interpretation whether we meant something different by this section. I'm sorry, Ms. Morrissey?
I think just as a general approach, certainly modeling the other provision that's there now would help with the consistency so that you are ensuring that to the extent the existing provision has been interpreted and applied, that courts will be looking to implement it in a consistent manner, and you avoid some of the potential that may come from different language. Is there any unintended consequences? The other thing I would note is that to remind the committee that Section 2 of the Criminal Code does define offender. Accused does not have a definition, but we know what it means. So an offender is defined as means a person who has been determined by a court to be guilty of an offense, whether on acceptance of a plea guilty or on a finding of guilt. So on balance, if the department were asked, is there a preference, generally we would tend to go with using the existing model just to ensure that you have a more likely consistent application of the similar provision.
And so, Mr. Finsmith's point, is your intention then that, you know, for people who've been accused while they're awaiting trial, that an order be placed? And so would that typically be handled through release or release conditions by a judge while they're awaiting trial? Was that the intention to compare the sentencing versus while awaiting sentence?
Honestly, the intention was just to take what we'd heard and to take the wording that was existing in the code and apply it to this section. Mr. Davies, I think, raised a good point. My point in only drawing the distinction between sub A and sub B is that I can imagine a court wanting to make an interim order to prevent an accused pending conviction, pending trial from owning an animal if there is a serious offense and, you know, a prima facie basis for doing so. So, but that, you know, there's no great intention other than it made sense to copy and paste, and copy and pasting appears to be more complicated than that.
So just to know where we are right now, Mr. Erskine-Smith, in addition to the language that you're currently proposing, I assume you have deemed these friendly amendments and you're accepting them. We're now saying 5, instead of the court may, we're saying the court may in addition to any other sentence it may impose. And you're striking, in all of the places where it says animal or a bird, you're striking the words or a bird. The conversation has been about whether or not we replace the word accused with the word offender in subsections A and or B, presumably B being more important than A. I understand. With the department weighing in saying that would create an inconsistency with the existing wording in 447, which has already been interpreted And I don't know that anybody's ever heard of a problem with the interpretation that's been given to that section. So may I make a suggestion, colleagues, that as opposed to trying, I get the point and I agree with you, Mr. Davies, the only thing is, given that wording is an existing, another part of the code, I don't know that it's wise to have two contradictory words, because then somebody's going to say there's a reason why we did that. So maybe we can move with that amendment to then just a debate, or is everybody in agreement with that amendment? Agreement? Everybody in agreement? So then we'll deem this amendment adopted. Mr. McKinnon?
Sorry, I'm not in agreement with using the word offender instead of accused.
We're using accused.
All right.
So, Mr. Varani?
Just 2 points. One, maybe Ms. Morency could comment on whether the current provisions under the code with respect to bail conditions prior to a conviction being entered are flexible enough to allow for precisely what Mr. Erskine-Smith has been referencing, a prohibition in the interim from having possession of any animals. And secondly, if we could just revisit, if we're looking at marrying the current 447.1 with Mr. Erskine-Smith's current amendment, there's also an issue of the ordering, right? That was also raised by Ms. Morency.
The department had mentioned that the ordering, it leads to the same conclusion. I don't think you're gravely concerned about the ordering, if I got that right.
That would be an issue for our colleagues, the legislative drafters, in terms of what is a usual approach. But ultimately, I think if the committee is concerned with what are the core elements that the committee wants to ensure are there, if they're there, I think you can address it that way.
Yeah.
I have no strong views on ordering as far as it goes. So I defer to drafters as far as what their preference is.
You did work with the legislative drafter on drafting
I worked
this.
with the yeah, I mean, I certainly didn't draft this myself. So so long as it gets at what we were trying to drive at, that's the goal here. So I defer to the drafters on.
Yeah, Ms. Morrissey?
The way Bill C-84 reads now as introduced,
Yep.
the definition of bestiality was added as a subsection 4 after the offense provisions, right? If they're following the usual order, the criminal code offense would say this is an offense, and here's the penalty, and in addition to that penalty, here would be the prohibition order restitution, right? And the definition normally would come at the end of the sequencing of the subsections.
So it's as simple then as taking, in terms of ordering, just taking the definition of bestiality and placing it as subsection 7 and bumping everything else up, right? Okay, so if that sounds fine to me.
So what are you proposing within the scope of your amendment? Because I don't...
It would just be an ordering issue where I understand the definition of bestiality would become subsection 7 and everything else would, so the court may, in addition to any other sentence that may impose, would now become subsection 4 and 4AB, breach of order, every person who contravenes an order, which is currently subsection 6, would become subsection 5, subsection 7, sections 740 to 741.2 apply, would become subsection 6, and the definition of bestiality would become subsection 7. That is what I would understand. Right? That's fine. That sounds fine to me.
Okay, but then you reference 5A and 5B, so,
Well, or now 4A and 4B.
which are now 4A and 4B. Okay,
So everything on my amendment just becomes 4A, 4B, 6 becomes 5, 7 becomes 6, and the definition of bestiality becomes subsection 7.
yeah, I understand. So basically just, basically what we would do, okay, so so again, the first line would be 4, 4A, 4B, 5, 6, as application, then definition of bestiality would move down to 7. Does everybody get that, colleagues? Because it's sort of, okay, everybody good with that? Yeah. Okay, perfect. So, agreed? Okay. So, perfect. So the amendment carries. Now we move to clause 1. Is there any other amendments to clause 1? If not, I'll ask for a vote on clause 1 as amendment. All those in favor of clause 1 as amended? Carried. There's no amendments to Clause 2. Does anybody have any amendments to Clause 2? Not seeing any. I'll move to a vote on Clause 2. All those in favor of Clause 2? Carried. Clause 3, we have 3 identical amendments, PV1, NDP1, and LIB2. With Ms. May submitted it first. She's not here. The next submission was NDP1. Mr. Davies. But
Thank
the
you.
3 are identical, so those 3 would all, the 2 that aren't carried would just disappear.
Thank you, Mr. Chair. Briefly, the way I understand the current section of the criminal code is that in 447 sub 3, it reads a peace officer who finds cocks in a cockpit or on premises where a cockpit is located shall seize them and take them before a justice who shall order them to be destroyed. So as it's presently worded there, it's mandatory that the seized birds be destroyed, and the proposed amendment would leave to the discretion of the authorities to determine if there's any ability to rehabilitate the animal or animals or birds on a case-by-case basis, to give that discretion.
Any comments on that one? Okay, so I think this is probably agreeable to everybody because we previously had discussed this at committee. Is everybody in favor of this amendment? Yes. Good. Carried. And then, is there any other amendments to Clause 3? Not seeing any. So shall Clause 3 as amended by that amendment carry? All those in favor? Carried. Now, the next amendments were PV2, NDP2, and CPC1, and those are deemed not receivable because of the carrying of LIB1 that was identical in terms of effect. So now we move to CPC2.
Yes,
Mr. Cooper.
thank you, Mr. Chair. This amendment would simply amend Section 490.011, which defines a designated offense in order to require an individual who is defined as a designated offender to register in the sex offender registry. Currently, it provides that an individual who is convicted of compelling the commission of bestiality under Section 160 sub 2 would have to register, and as well as an individual convicted under Section 160 sub 3, namely bestiality in the presence of or by a child. So what this would do would close the loophole so that anyone convicted of a bestiality offense would be required to register. It closes what I believe is a loophole and was supported in the testimony of the sergeant from the Ottawa Police Service.
Would that be bestiality simpliciter, though, that would be
Yes,
covered by this?
that's right.
Got it, okay. Mr. Fraser?
So can I just ask the officials for their take on this? Because, and maybe I'll just preface it this way, I'm just a little concerned with if we're making bestiality simpliciter, the effect of that being a requirement to be on the sex offender registry, that there could be circumstances where there is no risk to an individual, like there would be for the other instance where perhaps a child was involved or something like that, which completely makes sense. So I'm just wondering if I'm reading that correctly and what the department's take on that amendment would be.
So, as the committee may know, that the Sex Offender Information Registration Act was enacted in 2004. When it was first enacted, they only had subsection 3, the bestiality involving a child, as a designated offense. In 2011, the act was amended and the subsection 2 offense, the compelling another person to commit, was added. The simpliciter offense has, and maybe I'd go back one other step. In terms of when the SWORA was first enacted, it was to create a tool for law enforcement to be able to better track, monitor persons who are at a higher risk of reoffending, and through the listing of designated sexual offenses. Non-sexual offenses are designated, but the Crown would have to show that the offense was committed for the purpose or to facilitate the commission of a sexual offense. So it's always linked back to a sexual offense as a core criteria. The simpliciter offense has not been added either upon original enactment or when it was amended, primarily because my understanding at the time was that there was less evidence to show that maybe persons who engaged in simpliciter offenses were at risk of reoffending to commit a sexual offense against a person. I think the committee has received evidence from a number of witnesses that have provided other evidence to the committee to indicate some of the concerns that they've addressed in terms of linkages to other issues. But at its core, when it's listed for the purpose of the Sex Offender Registration Act, the intention is to try to prevent somebody who's at a risk of committing a sexual offense against another person. That's usually the criteria.
Yeah, I wonder, Mr. Morency, if you could tell us what are the consequences to an individual's civil liberties by being included in a sexual offense registry?
For sure, the consequences of being required to register are significant. The offender, I'm not a leading expert in the area, but generally the offender is required to register upon conviction, to provide their address, their names. If they plan to leave the country, for example, there are all sorts of requirements that they have to provide. So it is very much a tool that impacts the individual. And over time, there have been some challenges to the scope of that. As say, upheld because of the linkage to the objective, and it's tied to persons that the evidence shows are at a greater risk of reoffending. So the simpliciter offense is, in the way it's been treated to this point, a bit different than the other two offenses for bestiality.
Kenzie and then Mr. Davies, and then we're just going to take a brief pause because my colleagues. Yeah. So Mr. McKenzie.
I would just support this amendment. One of the things I think you will find in history is that the people who are convicted of bestiality offenses typically are looking for opportunities, and it may be as gross as it seems, but with dogs or horses or cattle, but it also spills over into the opportunity. They do tend to look for easy victims and children and so on. So putting them on the sex offender registry means that when it comes time to conduct investigations and so on, that's where you have to look to see what you have in your community. It's not to be penalizing innocent folks or anything of that nature, but it is to make the community a safer place. And I think that's the evidence we heard.
Okay. Mr. Davies?
Yeah, I had a question, and then I would like to speak briefly to the motion. My question, Ms. Morency, is if a person is listed on the sex offender registry, is that something that can be checked by community organizations at all, or this is purely an internal tool for police?
It's only accessible by law enforcement. Okay. And there are provisions in the code to permit an individual to apply, if there's a change in circumstances, to apply to have the registration varied. Mm-hmm. So there is a clear process that's in place to provide the checks and balances.
Because I have to say that I agree largely with what Mr. McKenzie said, that the sex offender registry, by definition, has people who've committed a sex offense, and a person who's committed bestiality has committed a sex offense. And frankly, there are, I think, a number of parallels, even without looking at hard empirical evidence, that someone who will take advantage of a vulnerable creature in secret and violate that creature in a sexual way, I think, just as a matter of common sense, tells me something about the nature of that person. And I would think that in this case we would want to err on the side of giving our police every tool that they have. I realize that an animal is not necessarily the same as a child, but there are similarities. I mean, they're both vulnerable. there's a vulnerability to that of an adult taking advantage of something who's not capable of giving real consent. And finally, I do understand that there are, as was pointed out by Ms. Morency, that there was evidence heard at committee that violence or mistreatment of animals is can be an indicator of further violence towards children or a partner. I think we know that there has been a link made in terms of domestic violence, often starts with people who are mistreating animals. So in this case, I would support the amendment.
Mr. Chair, I thank all my colleagues for their contributions and Ms. Morency always for her input. I'm in favor of the amendment as well.
Mr. Brandy?
Can I just clarify, Ms. Morency, in the context of the registry, we hear a lot about vulnerable sector checks. So people that are wanting to work in a daycare, a school, as a camp counselor for an overnight camp for children. Is this the kind of registry that is checked in a vulnerable person check to ascertain whether that person is appropriate for that kind of job dealing with children?
So with those types of checks, if a volunteer, before they can be accepted by the organization to volunteer, will have to present themselves to the municipal police force and submit a request to have a check done. The police organization itself does a check, and they will check through, yes, the registration, the SWORA and other sources that they'll go through to see if there's a conviction that's been registered against that person with that name at that point in time.
Mr. Erskine-Smith?
Just one last question. You mentioned evidence and when there's a previous attempts to update the sex offender registry, that maybe there wasn't enough evidence to add this to it. But then in light of the evidence we heard, specifically the evidence from the Canadian Veterinary Medical Association and the strong and Humane Canada and the strong link between sexual abuse of animals leading to sexual abuse of children, the evidence that we heard as a committee in the course of this study would suggest that it does make sense and it's consistent to add this.
While I wasn't privy to the evidence that was available at the time when it was originally enacted, it's certainly my review of the transcripts. I wasn't able to access all of the reports, studies that were provided to the committee. That I always think is a great idea if the committee's able to make those types of things available. But certainly on the transcript, I think the committee had a number of witnesses that spoke about the linkages between people who do abuse animals in whatever form and go on and commit other forms of violence against persons, whether sexual or other violence.
Thanks very much. I appreciate it.
Okay, so now I don't think there's any more discussion. All those in favor of CPC 2? Carried. And as I understand, although I guess my alleged advisor is smarter than me. He says that we don't have to adopt Clause 4 because by adopting the amendment we create Clause 4. I always think that you have to then still do Clause 4, but you don't. Okay, so Clause 4 carries because the amendment carried. So now we get to the title of the bill. Colleagues, shall the title of the bill carry? All those in favor? Good. Shall the bill as amended carry? All in favor? May I report the bill as amended to the House? All in favor? Good. And shall we order a reprint of the bill as amended for use of the House at report stage? Yes. All good. So colleagues, I'm just going to ask everyone to stay behind for like a brief 2-minute meeting, and I'll ask everyone else to leave. I'm sorry, because I just want to report on agenda and to have a discussion about what we're going to do on Tuesday of next week also. So if we could just ask everyone. Thank you so much for coming. We'll have another meeting at 10:45 that I think you'll find very interesting. This is going to be in camera. Yes, this is in camera. Yeah. So meeting suspended until we clear the room.
Thank you.